Hi everyone, welcome to Legal Talks by Desi Kanoon. I am Suyash and I am excited to have started this show. On today's show, we will discuss the meaning of the term Sui Generis. You might have heard this term very often, and as many of you might be knowing, it is a term of Latin origin. Let us understand its dictionary meaning. The Black's Law Dictionary defines it as of its own kind or class, or unique or peculiar. Let us also understand its meaning with the help of important judicial precedents. The first case that we will discuss is Mehar Singh Saini in reference. In this case, Article 317 of the Constitution of India was involved, that provides for removal of members of public service commissions by the President of India after an inquiry by the Supreme Court. The manner or the nature of the inquiry has not been specified. Therefore, it was observed that the Supreme Court is free to devise its own sui generis procedure to conduct an inquiry in terms of Article 317 to suit the facts of a given matter at hand. The next case that we will discuss is Daroga Singh versus B.K. Pandey. In this case, the Supreme Court discussed an offence that is sui generis, that is the offence of criminal contempt of court. Just like Article 317, the contempt laws of India provide powers to the judges who initiate the criminal contempt proceedings to remain in full control of the hearing of the case. The court discussed that in other criminal offences, specific procedures are followed, but in case of criminal contempt, custom-made procedures could be devised by the particular judge, making it an offence sui generis. Similarly, in the case of Paramjeet Kaur versus State of Punjab, it was observed that when the court orders a body to carry out a certain task, then no statute can limit its power to carry out that particular task, and such body becomes a body sui generis. In the same breath, the case of K.C. Vasant Kumar versus State of Karnataka held that the Constitution of India has a sui generis status because of its unique characteristics, and that there is no classification where the Constitution of India could fit, necessitating adoption of a sui generis approach for its interpretation. According to the Supreme Court, the general principles of interpretation may not be useful for interpreting the Constitution of India. And lastly, in the case of Federation of Hotel and Restaurant Association of India versus Union of India, it was opined that if a tax is imposed under the residuary powers of the central government and such a tax does not fall within any other classification, then it could be termed as a sui generis or a nondescript tax. A lack of discernible pattern could make an object or a situation to be sui generis. And another takeaway from this judgment is that sui generis also means nondescript. So, we have seen that an offense or a body or a procedure or a tax or even a constitution could be sui generis. In conclusion, it could be said that sui generis is an interesting term, having limitless utility both in the field of law and otherwise. The courts have used this term in situations where there has been a lack of classification. Thus, I hope you enjoyed listening to this show. I hope I was clear in explaining the meaning of this term. Please do not forget to like and subscribe us. And if you have any comments, feel free to make them in the comments section. See you next time. Till then, stay tuned.